After the leaked draft opinion showing that the U.S. Supreme Court may be poised to strike down the landmark Roe v. Wade decision protecting abortion access, we wanted to know how we got here and what happens if that decision is finally made.
News Center Maine's David Guilford looks into Maine's legal history on the topic.
Just puts more priority, more emphasis on state constitutions and state laws.
If this week's leaked Supreme Court draft opinion is upheld and Roe v. Wade is overturned, the focus will shift to what state legislatures have on the books. Within a year of Maine becoming a state and right up until the Roe decision, Maine's laws evolved from outlawing even hiding a miscarriage in 1821 to forbidding advertising contraceptive methods to not allowing any abortions that didn't save the mother's life. In the 1960s, after the FDA approved the first birth control pill, Maine repealed its contraceptive law. It also formed more nuanced abortion laws while publicly applauding the pro-life movement in the wake of the Roe decision. If Roe is removed, Maine Law School Vice Dean Dimitri Baum explained states have a lot of leeway.
States have broad police powers. They can pass basically any kinds of laws as long as they don't violate individual rights.
Maine's current laws allow providers to refuse to perform an abortion without penalty, and any living child born must be protected. An adult or a court must consent to an abortion for a minor. Abortions aren't allowed if the fetus could survive outside the womb, and insurances that cover pregnancy care must also cover abortions. Other states have much stricter laws ready to take effect.
Many other places throughout the South, in the Midwest, have these trigger laws that if Roe v. Wade is overruled, now we have a new regime in place.
Multiple states have passed these so-called trigger laws, which will restrict or outlaw abortion as soon as Roe is overturned.
The well-to-do women will be able to get it.
Dr. Richard Kahn is a medical historian and a retired physician and began practicing just before the Roe decision. He said women seeking an abortion who could travel to states where it's legal always have.
It's the middle, lower socioeconomic classes that it would really hit the hardest and be most difficult.
For now, Roe remains the law of the land, with state law in place, but subject to change in Augusta. David Guilford, News Center, Maine.
Chief Justice John Roberts confirmed the authenticity of the draft opinion this week, but called its release a betrayal of the confidence of the court intended to undermine the integrity of its operations.